Good afternoon. This is Helen Baptist. I'm the Senior Vice President of Strategic Partnerships, and today we're hoping to share with you some information that you'll find useful for your business around data privacy. And the reason I've been brought onto this is because we've got this great partnership with two of the best leading industry experts on data privacy, and they're going to talk to you today about that. So without further ado, I'd like to take us on to the next slide that talks about what we're going to talk about. And you can hear the Canadian accent in myself as I say about. What we're going to do, I'm going to give you a little overview of what we're going to talk about, and then I'm going to introduce you to the two experts we have on the phone. You'll see their mugshots or pictures, as I like to call them, and I'll give you an introduction to them, and then I'm going to hand over to them to allow you to really understand what does it mean when we talk about data privacy, why is it so important, and how should you think about data privacy in your day-to-day operations. We have a new resource for you all to look at, which is called the Fishbowl Guest Privacy Playbook, and the gentleman on the phone will take you through that as well as to what's in it for you and what things you should take away from that playbook and how you apply that to your business. And then we'll do a wrap-up, and in fact, the gentlemen that are on the phone have a new tool for us that will allow you to do a quick assessment as to how you stand on your data privacy and what the implications of that might be as well. So as you know, Fishbowl has been in the industry for about 15 years, and if you think about where we've come from, we started as an email provider, and now we're into this big data analytics, and with that comes changes in the way that we handle data and the way that you should think about the data of your customers and how you manage that and govern that in your organization. So in partnership with Morrison Forrester and SoCal Privacy Consultants, we created this guest privacy playbook that we're introducing today and will be available for you through your Fishbowl representatives for you to walk through and really think about how you manage data, what you say to customers, how you really control what you're doing with other people's data. And hopefully, you'll walk out of this with some ideas of what you can do to implement in your organization from the playbook and how that will really impact you on a go-forward basis. So let me introduce you to Andrew Serwin. He is the partner and co-chair of the Privacy and Data Security Practice at Morrison Forrester LLP. MoFo, as they're most affectionately known, is an international law firm with 17 offices located throughout the United States, Asia, and Europe. The firm advises clients across a range of industries and practices, including intellectual property, patent litigation, corporate mergers and acquisitions, business restructuring, and securities. On the right-hand side is Michael Cox, and that's no political affinity, right hand, left hand in terms of pictures here, but just the way they lined up. Michael Cox is the founder and president of SoCal Privacy Consultants, which helps clients establish lean, sustainable, and legally defensible privacy and security programs. Gentlemen, the stage is yours.
Thank you, Helen. I think I speak for Andy. We really appreciate the opportunity to work with Fishbowl, and this webinar is a demonstration of the commitment that they've shown to privacy. They get the fact that privacy is part of their brand trust, and that the entire ecosystem, it's important that the entire ecosystem assists in doing the right things on all sides in order to manage privacy. So what we'd like to start with is clarifying sometimes some confusion between privacy and security. Privacy is the bigger concept. It includes security, so you cannot have privacy without security. You can have security without privacy. Traditionally, privacy's sort of been around notice and disclosure, although you can't bury things in the notice. Providing appropriate choice, meaning opt-ins and opt-outs, depending upon the sensitivity of the data involved. Ensuring that the notice, that's your privacy notice, transparently discloses your data privacy practices relative to the data privacy life cycle, which is simplistically the data collected, data used, disclosed means shared or transferred to a third party, retained and disposed. So it's really important that you govern your data privacy practices consistent with your notice. One of the things that I observe with clients sometimes is legal is developing a privacy notice kind of in a silo or a vacuum, and the business doesn't really understand what's in the notice, and there's a problem when the practices don't line up to what's in the notice. In fact, that can be a deceptive trade practice, which the market makes you pay a heavy price for. If you omit something materially in the notice, that is also potentially a deceptive trade practice. So it's really important that you govern your data privacy practices consistent with your notice. However, one problem is, I'm going to delve into this a little bit more in the next slide, is that privacy is so complex and ever evolving that regulations, laws, and standards, we're a little too early, regulations, laws, and standards cannot really keep up with what's happening in the privacy world. So in order to really be able to manage privacy properly, you need to think about it from a risk management perspective, which we'll build on as this webinar goes on. Mentioned that security, again, is part of privacy. So when I speak to privacy generally, I'm referring to privacy and security. I will talk to security when, by itself when I talk to security. So security is about protecting the confidentiality, integrity, and availability of information. You do that through administrative, physical, and technical controls. There's this concept that's come about called reasonable controls. It's interesting that the California State Attorney General just 3 weeks ago, in guidance that she issued, said that the start to a foundation of reasonable controls to comply with California law is to adhere to the top 20 critical security controls. So if that's not on your radar screen, it probably should be, because California tends to be the leader that other states follow over time. So that's the top 20 critical security controls. It's not listed in the references. If we do an update to this, we will certainly add it. And the idea around defense in depth is that any defense can be defeated, and therefore it's about layering in various defenses to make it difficult. So that's the concept of privacy and security. Now, Andy, you've handled you've handled a ton of FTC cases, and some of the biggest. I think this helps differentiate privacy and security as well between the privacy events and the typical security threats. What are you seeing out there?
Yeah, and look, I think the way to really look at privacy versus security from a legal standpoint is, most of the time the privacy issues are a company whose data it is, or who has legitimate access, doing something that somebody disagrees with, but it's not typically been disclosed to a third party. There are exceptions to that, but pretty generally almost always involves a third party who should not have access getting access to the data. And so when we look at this overall, that's a good way to sort of look at it. What you see on the slide, obviously, is you see there are notice and choice issues, and so depending on whether you're dealing with the United States or this on a global issue, the concept of what's appropriate notice, what's appropriate choice does vary. But that's typically what you're seeing in a marketing context at some level, which is, what rights do you have to use my data or my contact information, and have you adequately disclosed to me what you're going to do once you collect my data, so I can have choice around whether I choose to give you that data, or have choice around what things I will consent to let you do with my data. And so I think that's one of the things you read about a lot of security breaches, but you do see laws like do not call, do not fax, also known as the TCPA, that really get to people don't always want to be hit with marketing type emails or texts or other things, and so giving them choices is at times legally required. It also can be a good business practice, because if you're ultimately trying to sell someone something contacting them in a way they don't like probably is not necessarily the best way to do that. Improper access, which you typically see is a trusted third party or an internal person with your company getting access to data that maybe they shouldn't have. It's not the same as necessarily a security event where it's gone outside the walls of the company, but it may be that someone in the company had no real legitimate right to see it or use it, but they did anyway, and that's, I'd say, more viewed as a privacy event than necessarily a security event. You could interpret that either way. Improper use and disclosure obviously deals with when you have data that you've collected for one purpose, perhaps you've decided later you want to use it for a different purpose and you haven't necessarily told people about that. So, in the U.S. we have a broader view of use and purpose than the Europeans, where there's a very purpose specificity principle that's typically followed. But again, you want to make sure people understand, generally speaking, what you're going to do with their data. Obviously, you have improper disclosure, and I'd look at that more as an issue of where you intend to give it to somebody, perhaps you shouldn't, but it's not someone coming in and stealing the data. And then obviously the last bullet point on the privacy side is you have improper retention beyond legitimate business purpose. If you have had my data for 20 years and you don't need to keep it that long, there are privacy issues with that data retention issue. There's other pieces to that, including in the litigation context, you have to balance that with. But overall, that's kind of a summary of the privacy event side. When you look at security, you're predominantly looking at external threats, though they can be internally enabled threats. And so that, an insider, I don't want to minimize the insider side of this, but that's a much more intentional act. It's not someone thinking, oh, I'm doing the right thing for the business, I think I have the right to do this. These insider threats typically are more like a theft of information or property from a company. We have seen some, just as a point to think about around tax time, we have seen people pretending to be the CEOs of companies and asking for all the W-2s of an employer and getting everyone's name and social, and then tax fraud can potentially happen. So that is a security event. It's not a malicious act by the insider. It's usually carelessness, but it's more of a security event than a privacy event in most people's views. You obviously also have the other third-party threats overall. And when you look at external, I'll go back to that first column on the right, the first bullet points, you can see state-sponsored actors obviously get a lot of press about certain countries that may or may not be trying to steal our intellectual property. You do see organized crime. You do see threat actors that are much more the sort of anonymous types of the world that have a different agenda that may want to come after your company. And then you do see occasionally unaffiliated threats. But overall, the market, I think, is set by a world in which organized actors are preying on companies, and you're the victim of a crime, but yet you're also facing legal liability and, frankly, potentially a lot of bad press over a data incident where you're being attacked by a nation state or an organized criminal actor.
And one of the things that I think is really important to note, we're going to hit on this again a little bit later, is that your third parties that you're providing data to face these same external threats and insider threats. And both you and your third party can be held accountable for your various roles. We'll get to that in just a moment. On the next slide, if you're going to, all of the big consulting firms put out data breach investigation reports. If you're going to read only one, someone in IT generally or the privacy or security official, I would recommend the Verizon Business Data Breach Investigation Report. It has by far the richest set of data in which to draw conclusions on. This happens to be a quick view related to the hospitality industry. And the 2015 report. Unfortunately, the 2016 report just came out yesterday, and it's pretty dense. I have not had a complete review of it. One of the key things that comes out every year is that it only takes minutes for a hacker to compromise your network. And yet, too many organizations are taking months to detect that there's someone in their system. And obviously, the longer someone is in your system, the worse the impact is going to be. And certainly you're not in a legally defensible posture if you don't have the ability to detect. So, you should know that there's plenty of research out there, including the Verizon Business Data Breach Investigation Report, that demonstrates that this particular industry is very vulnerable and needs to mature, much as financial services has in the past, and now healthcare is beginning to do. Any other thoughts on that, Andy?
No, look, I think that's right, and I think what you're seeing is, I just wrote, as an atmospheric, I'll say, I just wrote an op-ed on this that you could probably find easily, which I think is, we're moving from a B2C threat to a B2B threat in this space, and by that I mean, credit cards have been the easy prey of this space. It's not that I think the security wasn't taken seriously, I think it was, but they were, it was much easier to move them, if you will, and fence them, for lack of a better term. I think the card brands and others have taken steps to try to make that harder, and I also think that, because they have been the low-hanging fruit in some ways, there's more value with other data. And so what I think you're seeing is ultimately a shift in the threat to still include credit cards, and we'll always be dealing with that, but also dealing with what other types of data can be monetized. And the harder we make credit cards to steal, the more likely it is people will figure out other business models in this space. And so when I say we're going from B2B or B2C to B2B, I think what we're seeing is not just a threat to your business of being attacked to get data regarding consumers, but also your threat profile includes attacks on your business to try to get data that others can use against your company, whether that's, again, the W-2 threat, it's taking emails and trying to blackmail the company. There's been ransomware where things get shut down, and so you can no longer look at this as just an issue of, oh, if I have or don't have consumer data, I'm either okay or not okay. You have to look at the internet in a broad sense, with IoT and everything else being a core part of everyone's life and business, and that being shut down or that being in some way can have a critical impact on your business. So I think when you look at this and you look at where the Verizon reports have been and are going, you can't just look at it and say, oh, there were these many PCI breaches, and that's all I'm concerned about. One thing I will say as well as we go through, we're happy to get questions from the audience and deal with those as we go through. We'll have some time at the end as well, but if people have questions, they should definitely send them in. But I think, Michael, that's how I'm starting to see the threat is really,
right.
It's no longer, oh, it's the latest PCI breach. I mean, most of the breaches probably on my desk right now are, these W-2 style attacks or other similar attacks on the business where you may have consumer data, you may not, it really doesn't matter.
Yep. And, another point, a couple of other points that come out on this, you can see how frequently employees click on phishing emails and attachments. This is called social engineering. And then a macro gives access into the system, and voila, all it takes is one click and someone's in. Additionally, about 99.9% of all exploited vulnerabilities were compromised more than a year after a security update was published. There's just no reason not to be regularly patching systems. So, one of the things that really strongly comes out in these Verizon Business reports, if someone's going to target you, they're going to get in. What you want to do is make sure you're doing everything reasonable to prevent that, and those are reasonable practices that are well vetted, well known, that everybody should be doing, and they prevent 96 to 98% of all breaches, and in doing so puts you in what I call a legally defensible posture, which we'll get to in just a moment.
I think we can probably pivot to the next slide. Yep. And so I think, look, one of the things to think about is I do tend to like physical analogies for cyber. And the way to think of a breach, I've been, for better or worse, doing these for more than a few years. And in the beginning, everyone's answer was, we'll build the highest wall and no one will penetrate our defenses because we are, X company, and that's that. And I think whether that was or was not true in the late 90s when the internet started to really grow, it's not true now, because what you have is state-sponsored actors and organized crime being one of the main threats in this space. And you can no more expect a company to defend itself from a state-sponsored attack than you could if the Army or Navy of a foreign state decided to invade San Diego, which is where we sit. You wouldn't expect a private company to be able to repel that attack. They don't have the resources, they don't have the experience, and that's really what we deal with. And so a lot of the ways companies are dealing with this now is, it's not that you concede your perimeter, but you concede the fact that someone, if they want to, will get in, and you try to do things like segmentation and make it harder. So once someone's in, they can't simply run through the entire network and get whatever they want. You've got layers of defenses, which is what Michael was talking about with defense in depth. But the more doors you have, obviously you don't want to choke the business off, but those kind of segmentations can be the difference between, I've worked on a very large public breach where the difference between it and some of the ones that were even worse was the segmentation around the credit cards was so good that even though someone got into the corporate network, they were unable to get the credit cards. And so you have to think through, what's the cost associated with these types of measures, what's the business interruption, but also, do you want to be the next company that has a very highly public breach and a lot of litigation around it? And so I think you really have to think through, again, not just what do we think is legally sufficient right now, because that is an evolving standard anyway as we get into this. And so even if we assume what's good today is good today, it may not be good tomorrow as threats continue to change. But the point is, this is not a compliance function, it's not a legal function. This is a core business function for any company, which is managing risk around information. And that's how you have to look at it. And so you have to comply with the law, you have to comply with what you would say is the sort of minimum security standards. But the question to ask yourselves is really, if you are dealing with that, and that's your approach, are you putting yourself in a position where you're more likely to have a breach that could be a very material event for your company, even though you've technically legally required? So I think that's really the first thing to think about. We have seen now, again, this is a governance issue to me more than anything else, and so you do see that incidents have had an impact where senior executives and others, there's always noise about trying to make them liable potentially. That hasn't been successful, I'd say, yet, but it does raise, particularly for publicly traded companies, but for others, with investors and just companies generally, concern about what's the right standard for governance. And that's not always the clearest thing, but that's really where I think you have to be looking at these issues, which is, again, it is a governance issue, not a compliance issue to say, here's what we think the law requires and that's what we're doing. That may be what you end up doing, but how you get to that conclusion is important. And you have to fit this overall into your overall risk tolerance as a company, meaning you can't look at cyber risk differently than you'd look at environmental risk or other risks you may have. You want to have a unified approach so that it is as defensible as it can be if the worst case scenario happens.
And what we do to help operationalize governance is we establish a system for owning risk in an organization. And that doesn't mean that you can just accept any risk. You need to be able to defend your actions and inactions from the perspective of being able to defend it to a regulator, plaintiff, attorney, judge, or jury.
And look, the ultimate answer here, though I am the lawyer here, I will tell you the law is not the final answer here. And as Michael's going to talk about, I think on the next slide, ultimately, this is a core trust issue with your customers. And if your customers don't trust you, they're not probably going to want to do business with you, and they're probably not going to want to share their data with you. So you have to look at this from the customer side and say, is our experience sufficient to build trust to enable our business to gain the information we feel we need to come to a better business outcome for both us as well as our customer.
I've seen some research that says that about 2/3 of customers don't trust what the brands have to say, and then they look to their friends and associates to ask them. They don't specifically ask, is this technology privacy trustworthy, but they do. It's implied in the aspect of their asking, do you trust this technology?
Well,
I know you've done some research.
I have, and so one of the things to keep in mind, I've done a lot of research on trust and privacy, and I think security and privacy are very different apart from concepts, just how people view them, at least in the profession. There is some overlap in how consumers see it, but the bottom line is when I've researched this, in 2011 the number was 39%, now it's I believe 35%, but just in the general population, we'll call it 30, close to 40% of the people are making buying decisions based on privacy. And I showed that research to some people initially. They went, well, that's interesting, but it's not that big a number. I went, well, if you think about it, it is a huge number because most products are not privacy products. And if I said to you, someone decided to buy a car on, 39% of the people made buying decisions on what car they bought based on something that had nothing to do with the car, you'd say that's pretty important. And I think that's really one of the takeaways is this is an issue that cuts across any business. And if you're willing to walk away from, call it 1/3 of your customers, then you can ignore it. The reality is that's a huge issue for anybody. And I think the other piece is I've tried to do research around who is concerned about privacy and why, and I've got ways to do that. And if you look at the people who are very concerned about privacy, who happen to be higher income, higher education levels, and in the baby boomer generation, so a lot of target customers, it's about 83% of the highly sensitive people on privacy are making buying decisions based on privacy. So again, you really got to look at your market demographics and say, do we have a population that's concerned less about privacy or more? And if it's more, it can be a huge issue that frankly has nothing to do with your products or services, but has everything to do with your revenue.
Yeah. So unfortunately, a lot of organizations don't get the concept of trust economics or brand trust until that inevitable breach happens, and there's an erosion of trust, and you've got to win back stakeholder confidence on all levels. So we'll move on to the next slide. And what I want to talk a little bit about before we jump into this slide is obviously POS data, PCI data is something that is of concern in this industry. Fishbowl does not have the full pan, so therefore does not trigger PCI. That Coal-Fire did a study on that. What we're primarily talking about today is a bigger concept than just PCI data. We're talking about personal data. PCI data is a subset of personal data. Personal data is generally defined in the U.S. by state law, and it does vary. I tend to break, when I'm working with a client, personal data into 4 different sensitivity levels. Highly sensitive, if it were to be compromised, would definitely be a breach. Then there's sensitive, less sensitive, and non-sensitive. I did that based on some research actually Andy did, and also taking into consideration what, if it were compromised, would be a reportable breach. And so one of the reasons I do that is, again, as I look at things from a risk management perspective, I don't believe in a one-size-fits-all approach. If you think about data sensitivity having a scale and control strength having a scale, you want to match data sensitivity level to the strength of control. So if you have a third party and all they are getting is name and email address, if that were to be compromised, it likely would not be a reportable breach. We want a modicum of controls. If they've got all of the sensitive data, highly sensitive data, we want very strong controls in place. So, just trying to differentiate a little bit between personal data and sensitive data. The EU defines sensitive data much more broadly than the U.S. does. Our focus here is primarily on U.S. law, but you need to be aware of that.
Yeah. And one thing I want to talk about is sort of the opt-ins and opt-outs here as well, which is, everyone has their story about this on the internet, and for better or worse, one of my probably main hobbies is I happen to be a baker, and so I will end up on Amazon more than I probably should be buying things. And you know, all of us have the story of the thing I just bought on whatever web service I use following me around the internet for 2 months after I've already bought it. And I think one of the challenges of this space is we do try to give opt-ins and opt-outs. Companies obviously want to sell more products and services, and they want to get the message out, but you've got to be, you know, there's probably a few more steps down the road to take of really tailoring those messages to not to be what I just was thinking about buying or what I just did buy, but rather what I may want in the future. And I think the other thing is what I've really been challenging companies to do is, with research I've done, and frankly Pew Research has done as well, not everyone wants those emails, and not everyone wants those marketing contacts. And so it's, again, not to say it is legally improper, it may be, but part of the challenge of this space of targeted advertising is trying to target the people that will be responsive to your message and the channel in which you are communicating to them. So I think that's one of the things you've really got to think through as you're looking at use of data, you know, really for analytics and marketing and opt-ins and opt-outs, is really be thoughtful about how you reach out to people, not because it's legally required, but because it's good business, and it probably means you'll have a more successful campaign. The person that may want to be texted may not want to be emailed, or may not want to be called, or may want to be called at certain times. And the more granular you can get on really getting that right, the better your ROI will be when you do these kind of campaigns.
And so in terms of Fishbowl's analytics, although there is no full pan there, which means that the PCI is not really triggered, Fishbowl's analytics should be discussed in your guest privacy notice. We've provided a sample of how you can do that in the back of the guest privacy playbook. And then, Andy, I think we need to probably do a slightly deeper dive in the about some of the opt-in issues relative to SMS.
Yeah, and so one of the areas that's probably the most heavily regulated is, frankly, the do not call laws and regulations, which include the SMS regulations. And so it has been a hotbed of plaintiffs, class action lawyers suing for statutory penalties. And so it's again one of the areas where I would say you really want to be careful and make sure you're legally compliant, because it is a trap for the unwary, and these suits happen more than you'd ever think. I will also tell you, just as a matter of course, I've defended a number of these. There are call recording laws as well, so it's a related issue but a little different. If you have monitoring or recording going on of your customer service calls or any kind of calls, you really want to make sure that you're playing a recording, or somebody is informing people, both inbound and outbound, that the calls are being monitored or recorded, because there are statutory penalties potentially in play as well there, just like the TCPA. And so just as a kind of a practice tip, you really just want to make sure your systems there are pretty tight and work, because the numbers that the plaintiff lawyers will put up are pretty high. But if you look at the, you know, again, when we look at the guest privacy kind of playbook that Fishbowl has put out there, you know, there are discussions of the exact points we're talking about, which is kind of erosion of trust, and how do we kind of get at this from a TCPA standpoint. I will tell you, it is probably legally the most risky marketing you can do in many ways, because the law is much more restrictive on SMS than it is on email. I recognize all the platforms are moving there, but you know, the key thing to me is making sure you have the legally required consent in the context you need it. And so, particularly when you're using what's called an auto dialer, which most companies probably use some variant of, you've got to make sure if these are marketing emails or they have marketing content, that you've gotten what you need to get and can prove you got it, because again, those are each text. The argument will always be about what's the statutory penalty, is it per text or per violation, and what does that mean? these things add up very, very quickly. And so the playbook provides you an overview. Obviously, none of us are saying that you can rely on that and legally you're good to go. But you really got to look at that as a guide, but also get counsel to tell you exactly where the lines are. There's some good resources out there as well. But it's one of those areas where, again, I can't emphasize enough that making sure you're doing that right can save you a lot of pain on the back end, because people are very vigilant about their texts, even in this age of sort of unlimited texting. The view still is when you call my cell phone, which is another hot button in this space, or you text me, these laws were sort of drafted with the eye that that was a per minute or per text charge, and sometimes it still is and sometimes it's not. But again, that's the view of the law right now, and so you've just got to really make sure that you're getting consent where you need it, particularly if you're calling a cell phone, particularly if you're using an auto dialer to text or call. So Michael, I don't know if you had other thoughts on top of that. But.
No, I think we'll move along here. I think I've kind of addressed the importance of the data privacy lifecycle, privacy practices lining up to the privacy notice. Another thing I'll point out is that you should have a good, solid approval process for those privacy notices. In other words, someone should be formally signed off on this as being accurate. And then good versioning and document control. If you have to reproduce the privacy policy that was, or notice that was in place 4 years ago, you need to make sure that you can demonstrate that that was the one in play. Any other thoughts, sir?
No, I mean, I'll start just as kind of a, what other are the hot button issues for regulators. Children generally, but certainly children online has been and will continue to be a hot button issue for the Federal Trade Commission, which is really the main privacy regulator at the federal level in the United States, as well as attorneys general. And so, there's what the law requires, and again, I think we have to be sensitive to the fact that, there's what a regulator would look askance at, whether there's a law prohibiting it necessarily or not. And so you just want to make sure that, when you're engaging, the federal law really is children 12 and under is the target of that law and its online conduct, and there's certain things you can do with parental consent, there's certain things you can't do without it, and then there's a variety of things you probably just can't do no matter what. But it's important to note that even if you're not technically within COPPA, which is the federal law, you want to be thoughtful about how you're marketing to children, because there have been, with certain types of products and services, attorneys general really, again, not taking a very dim view, I'd say, of certain marketing practices, either directed to children or involving children. Geolocation data and choice is another big one. I think there's been some action at the Federal Trade Commission. There's been some action at the AG level, but when you're basically, if your app allows you to track me when I'm not using the app, or it tracks me and I don't understand that, and it's not really, again, going back to an earlier point, core to the service you're providing me, it's not that that is on its face illegal, but people may ask questions as to why are you doing that? And if your answer is, we don't have an answer, or we just wanted the data, it's, having defended more than a few of these cases, that's not necessarily the best answer you can give a regulator. So I'm not saying don't do it, I'm not saying there's a legal restriction on you doing it, but you really need to think through, if you're going to collect a data stream that is sensitive, like geolocation, why are you doing it? Have a defensible reason for doing it, and that can be a business reason. I'm not saying it can't be, but don't just collect it just to collect it, because you simply enlarge the surface area of attack, if you will, by a regulator without really a corresponding business value being added. Do not track is kind of a, I won't say related, but similar hot button issue, which is one that I referenced earlier, which is how much am I being tracked when I go to a site and search, whether I search in a search engine or search somewhere else and say, oh, I'm really interested in this product. How is that data used? Is it passed to third parties? Am I tracked across websites? Am I just tracked on your website? All of those things have privacy implications. You want to really think through, from a data perspective and a legal perspective, what's the appropriate line to draw.
Great. So we're going to highlight just a few key points regarding having an effective privacy and security program. One is you need to obviously establish clear roles and responsibilities. This starts with having a formally designated privacy official and security official with clear roles and responsibilities organizationally for privacy and security. I think it's important. There's no requirement to data map. When I build privacy notices, I'm a non-lawyer. The first thing I do is I data map so I can see what data is being collected, how it's being accessed, used, for what purpose, who it may be shared with, and how long it's been retained and disposed. And now I can transparently articulate in the privacy notice all of those privacy practices and make sure that the notice and the privacy practices line up. More importantly, though, should you ever be breached, and we all are saying that's going to be inevitable, if you provide that regulator or that auditor your data map and walk them through your data map right off the bat, you're going to be demonstrating that you've got good governance. It's great operationally for new hires. It's a useful tool when you do your periodic risk assessments to actually go through the data map first. That's what I do. I can't speak enough for, in fact, I had a chief privacy officer at a major public company yesterday say, well, how do I know I have all the third-party agreements in place that I should? And I go, well, in addition to looking through your agreement database, if you're data mapping, you're going to know who those third parties are. And it was sort of like an aha. We're underappreciating the value of doing data maps, so I always recommend those. Obviously, you need to have written, comprehensive policies and procedures. I'm calling out incident management here because when that inevitable incident occurs, you've got to have some kind of policy and procedure to guide you through the process. You need to understand what to do when, what to do first. A lot of mistakes can be made, and you can't be learning on the job. You really should be doing tabletop exercises to make sure you know how to manage those incidents. Training is obviously huge for new hires. Should probably be doing it annually. Some specific on-the-job training when it's related to a particular role is important. I highlight roles-based access controls here because I find that this to be a major weakness in a lot of organizations. What this really means is you give someone only the minimum necessary access to personal data necessary to fulfill their regular job duties. And that means that you need a number of different roles with different rights which need to be properly authorized and periodically reviewed to make sure you keep that tight and keep the access under control. And that includes what's referred to as least privilege or those people with more advanced privileges. Yep. And then finally, there needs to be some way to kind of monitor the effectiveness of your program. Two ways to do that. There's a requirement to do a periodic risk assessment. I generally recommend that to be at least annually. Of course, assessing risk needs to be part of what we call privacy and security by design, embedded into your regular work so that you're anticipating risk and applying reasonable standards of care along the lines that we've been talking about. And then also doing a controls evaluation. So whether you're trying to adhere to ISO or the top 20 critical security controls or both, you're looking at requirement by requirement on a periodic basis to make sure that you are that your controls are effective. So those are two ways in which you can monitor the effectiveness of your program. We actually provide 11 questions at the end, which can help you do a little bit more of an assessment of how you rank up. So here we're talking about, we talked earlier about third-party risk and how third-party parties have the same exposure to insider threats and external threats. There's really several things you must be doing here. One, we talked about, disclosing in your privacy notice the analytics companies and other third parties you're working with. You don't have to name them, but you need to at least identify the category of third party. But more importantly, your obligation before you provide personal data to that third party is to do three things. One, conduct proper due diligence to make sure they have an appropriate privacy and security program in place. 2, properly contract with them to create appropriate contractual obligations around protecting and safeguarding that data. And 3, monitoring them in some way. And again, I apply kind of my risk management data sensitivity to this approach, meaning that if all of they're getting is name and emails, well then it might be a very light due diligence. If they're getting highly sensitive information, the due diligence will be greater. Now, one of the things I recommend here is that you have a contractor's database so that you can easily demonstrate that you have governance around all of the third-party service providers that have access to your data, and you can see what due diligence has been done and how frequently you may be monitoring them. Andy, the international cross-border transfer space has been changing recently. How
yeah,
about that?
Yeah, and it has been a bit of a interesting set of issues to deal with, to be not very candid. To be a bit more candid, it's a bit of a mess. So I think what you have is we had a framework that had worked up until relatively recently called Safe Harbor. For a variety of reasons, the European Union became very concerned about that, and so now we're in a place where there are some new options that are potentially out there, but I think there's a lot of thought going into whether they are, on the European side, sufficient or not. You also have what's called the GDPR, so European law is fundamentally changing, will go effective really in the next couple of years, but everyone's very focused on that, and so you really, if you're moving data from Europe or other countries to the U.S., whether it's employee or customer, you really need to think through how you're doing that, what the legal compliance strategies are. That's probably a webinar in and of itself. I'll move on to sort of breach. You know, having a plan is critical, but making sure you understand who the right people are that should be in the room to make the decisions you're going to have to make that may or may not even be within the best drafted plan you can imagine is critical. And you're just going to have to make a lot of very hard decisions very quickly, and in quickly I mean within the first couple of days if you're lucky, and you really want to have thought through, whether it's through a tabletop or a different way, how you're going to deal with that. And that's where I see companies really get hung up, is they don't fully understand the velocity of some of these decisions, and they struggle. Cyber insurance is not a mature market in the sense where all the risks are understood and it's well priced out. I think the insurance companies are struggling. I think companies are struggling to say what's the right outcome, what's the appropriate risk shifting here, and what's the appropriate price for that. And I think that market is, as I said, immature. I don't think we know all the answers yet, and so it's an important thing to consider. It may be the appropriate thing for your company to do. Some companies have it, some companies don't. You don't want to not have it simply because you haven't thought of it. You want to think through, is it the right thing, and how much would it help you in a data breach, particularly depending on the data set you would have.
And because it's not mature, and there are no standards, although there have been some proposed recently, you really have to understand the exclusions and limitations and the sublimits. You may think you've got certain coverages, or your board or C-levels may think you have certain coverages that when the worst happens, you'll find you don't have what you thought you had.
Right.
And you've got insureds suing carriers because of this misunderstanding. It's really important if you're going to get cyber risk insurance to make sure that you're working with someone competent that can advise you in that space.
And I think, I know we have a few more slides, but if we have questions, you know, we're happy to deal with some of those as we go. I think our next.
Hey, Andy, it's Helen. I have a question that's been sent in by somebody, and the question is, once a suspected breach has occurred, what would be the first thing that should be done by the organization or by the person responsible? Not the person who caused the breach, but who in the organization responsible.
Right. No, great question. One of the most important decisions you're going to make is, are you bringing in a third-party forensics firm to help you understand what happened? And if so, are you that under the attorney-client and the work product privilege? And so It's not that I think that the lawyers should run these breaches. This is a multi-stakeholder process, but I think the first thing you have to do is probably think through that, because that decision, if you come up with a report that says, here's what happened, comma, and the reason it happened is you had an incident 5 years ago and didn't fix it, and it's the same incident, that's a very bad outcome with a regulator. And so you've got to really think through, that's probably the first thing that's going to get presented. I think a 1 and 1A scenario is you really want to have an incident response group. That could be 3 people, it could be 10 people. I would hope it's probably not 10, but it's probably somewhere between 2 and 7 that get together and say, here's what we're doing. And so that way the key stakeholders from every part of the company are having input, and no one's going to get their way every time, but at least everyone gets heard and everyone understands the risks. So I'd say those are probably the first 2 things you need to deal with.
So as a follow-up to that then, so you've talked about this emergency response team, if you will, crisis management team of 2 or 3 or however many people are appropriate, but who ultimately within the organization should be responsible for owning that guest privacy or data within the organization? When a lot of our clients are lean organizations and they have maybe 2 people in the marketing department and 1 person in IT and so on and so forth. So where should that be held, and who should be held accountable for that?
Yeah, no, look, I think if you have a major breach, it's the CEO is going to be the one making the call. I'm not saying that's the person who needs to or legally required to, but if it's a material event about the company that could have a brand impact, the CEO is probably going to be having a significant amount of input, irrespective of the company size. I think in a leaner organization, you've got to have, the key is, and this depends on whether it's a employee breach or a customer breach, but you probably want to have, HR, the gov relations or PR function, whatever that is, someone from legal, someone from IT at a minimum, and then, obviously the comms, wherever that sits, but that's core, I would say. And for some companies that are bigger, information security is a separate function, or security is a separate function, but you've got to make sure all the people that are going to have the blowback on this have a seat at the table, so at least they can be heard. In bigger companies like banks, you'll have risk officers and things like that, but for a lean organization, that's really what you're looking at, I think.
And part of what we do when we do a gap assessment, we're advising a company, is we're helping them customize how governance should be managed in their organization.
Great, thank you. So to continue along, just to make sure that we're respecting people's time here, I think you've got some resources and references that are available here.
Yes, so we again we've developed a sample disclosure regarding just the fishbowl analytics. I mean, if you're using another analytics company, God forbid, we can't obviously represent that. I've done no analysis there, but this does accurately represent the current state regarding fishbowls analytics. Now, we're not addressing any other restaurant privacy practices. It's strictly related to fishbowl analytics. We also provide sample disclosures for marketing opt-ins, and you'll see email, SMS, also paper sign-ups, and some other things. There's also a wealth of industry resources like DMA, Direct Marketing Association's guidelines, also a number of privacy law regulations and guidance. FTC's guidance is in there. You'll note I did this myself, Andy's Information Security and Privacy, a Guide to Federal, State Law and Compliance. I have that as my desk reference. It's a very comprehensive and it's very comprehensive and updated annually. He also has an international version of that as well. I guess the other 3 things that when we update this in the future, I'd add the NIST Cybersecurity Framework. I'd add the ISO 27001 to 2013 version, and then the top 20 critical security controls. And then I guess as a concluding some takeaways, again, one of the things you have to understand is at the end of the day, the guest feels like they own their data. And because of that, the company and collecting it needs to respect that and manage the customer or the guest expectations relative to privacy. We've talked through, I think, a number of these others. If we can go to the last slide. Unless you had something else, Andy.
No, I was just going to add one thing also to think about as you're looking at, obviously, there is the guest privacy playbook that you can get from your Fishbowl rep, and also, obviously, to the extent you have concerns or questions, one of the resources you have, obviously, is your Fishbowl rep to help you with some of these issues.
Yes. And on this slide, we're again referring back to the fact that compliance can't just be a check-the-box type of issue. Privacy is complex and ever evolving, and laws, regulations, and standards can't keep up. So really, you want to start thinking about it as a risk that needs to be managed along all of the complexities and dimensions that we've talked about today. Designating a privacy and security official, a system for owning that risk, and obviously internal or external experts can be helpful in developing a program. And lastly,
so speaking of which, obviously we've got this very strong partnership with you guys, both Michael and Andy from SoCal and Morrison Forrester. I will tell you, when we've been in client meetings and we mention these organizations' names, it's very well respected. But at the end of the day, we don't make legal counsel decisions and recommendations on behalf of ourselves. So we would recommend that you reach out to these gentlemen and their organizations if you have questions around data, privacy, security, breaches, those kinds of things. They're more than welcome to, they're more than open to helping you out as you try to figure out how to navigate this important topic and you protect your organizations and yourself at the end of the day. So just to wrap up then, if we go to the next slide, Michael, do you want to talk about this one quickly?
Yes. So we've developed a 11 question. It takes just a couple minutes to go through it. Self-assessment. It's the foundation. I mean, obviously, I'd have to give you 300 questions to really assess your maturity, but it's to see whether the foundation is in place. And this will give you a sense of where you're at foundationally. And you will get a score. You'll get how you answered the questions in case you want to have a conversation with a C-level or someone else. So I appreciate the opportunity to talk with you, and I hope you'll find the guest privacy playbook of value.
Thank you, gentlemen. It's very much appreciated that you're very busy with protecting the privacy of lots of companies and litigating as it seems. And so I want to thank you for taking time out for being on this webinar with our clients. And just to reiterate again, you'll get a follow-up email from us at Fishbowl after this webinar. It will include a link to the copy of the Fishbowl Guest Privacy Playbook, the privacy statement. We'll also send you the link to the questionnaire, the 11 questions that were just referenced. And then we'll also include contact information for these privacy experts so that if you do want to reach out, you can. If you have questions about the Fishbowl Privacy Playbook, feel free to reach out to myself, Helen Baptist. We'll include that information in the email as well, or Aaron Levine, who is our Chief Financial Officer. So we can help get the right answers for you as we move forward. Again, thank you for joining us for the Fishbowl webinar on privacy and data, and enjoy the rest of your afternoon. Thanks.